This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
And we've got Todd Lutsky from the law firm of Cushing Dolan joining us now for Ask Todd. This is your chance to ask Todd your questions about your estate plan. It's a great opportunity here, right here on the air. The studio line is 888-205-2263. That's the number to call if you'd like to ask Todd a question about your specific estate plan. Again, it's 888-205-2263. Tucker's got the phone lines open, so get calling so that you get to ask Todd your question about your estate plan. Mr. Lutsky, how are you today?
I am never better, and you?
A little bit tired.
Oh, no.
I got a 5K that I'm training for this weekend.
Okay, how's that going?
As I said, I'm tired. It's an anti-venison 5K.
Anti-venison?
I'm going to be running for dear life.
That's good. That's what most people do when they run.
Let's talk a little bit about the unfortunate situation that, again, even if you have the best marriage ever, this is what happens.
Okay.
One of your spouses dies first.
Yeah.
Not one of your one of these spouses.
One of these spouses
dies first, not one of your spouses. What happens if a spouse passes away and they haven't done any estate planning? How do things work at that point?
So, we talk a lot about mistakes in the planning world, or when to review your estate plan or update your estate plan, and certainly death of a spouse would be one of them, right? And so if you die and you've left a spouse and you've done no planning, and we'll talk about even if you've done planning, right, what you should do. But if you've done no planning, it's really going to be a function of how your assets are owned. I'm going to tell you that most of the time, spouses, they own stuff jointly. It's not uncommon, right?
Yeah.
They got the joint bank account, the joint brokerage account.
So that sounds great. Everything should be easy, right?
Yeah, the house is joint. Both names are on it. Your beneficiary on the 401k, spouse, life insurance.
What's yours is mine. What's mine is mine.
That's how it is. And that's exactly what would happen. I'd tell the spouse, you accidentally avoided probate because of how you owned it. You are going to get everything. That was easy. And you're not going to pay any death tax, state or federal. Well, that's all good stuff. Yeah, except the problem is, depending on what you're worth, you're not going to shelter any assets for estate tax purposes because of this thing called an unlimited marital deduction, where everything that goes to a spouse you get to deduct against your estate tax. So if you've had a federal or a state death tax exemption awarded to you just because we get them, you lose it. So, especially in the state world anyway, federally it's possible you could save it later, but you lose it. But, more importantly, and so basically you're creating a bigger tax bill for the surviving spouse. That's the bottom line. And, of course, a probate problem on the second death. And, of course, how the assets end up going to your children on the second death is going to be a disaster if the survivor doesn't plan. And that's my point here. Even if you're married and you've done planning and you lose a spouse, you still need to come in. I was just emailing somebody before the show on that same thing. They weren't thinking that far ahead. That you still need to come in as a, single person now. You're single. So you need to figure out, one, how to update your plan as a single person. And then you also need to not forget that the plan that you went out of your way to put in place, we have to now take and, basically cross the goal line with it, put it into action, if you will. That's called the estate administration process for the deceased spouse. Folks, you got to think of these things. These are things that you should think about when someone dies.
Talking with Todd Lutsky from the law firm of Cushing Dolan. If you have a question for Todd about your specific estate plan, this is the time to call. The studio line is 888-205-2263. Again, it is 888-205-2263. We're going to take a quick break right now, but when we come back, we're going right to your calls with Todd. So, again, that number, it's 888-205-2263. More Todd Lutsky when we come back.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network.
As promised, it's right to your calls with Todd Lutsky. First up, we've got Vinny in Haverhill. Vinny, you're on with Todd Lutsky.
Hi, good morning. I just had a question about the protection from a nursing home from my mom's house.
Okay.
She doesn't have a trust. She owns the home outright. It's a two-family.
Uh-huh.
She lives in one apartment. My sister lives in the other.
Okay.
About 10 years ago, she put my sister on the deed. And so I just didn't know if any of that would offer any protection, considering they both live in the home.
Well, not tremendously. So, I mean, basically, when you add someone's name to the property, there's a lot going on other than just nursing home protection here. So, a couple of things. One, when you have a child living in the house and you put their name on the deed, so you've created a 5-year waiting period, and only half the house technically would be protected if you've gotten beyond the 5 years. I mean, I don't love the idea of putting a child on there because now she's accidentally disinheriting the rest of her family. Now, I mean, you're clearly a child and there might be other children, siblings that you have, but if it's only jointly owned with one sibling and she passes, it's going to go to that surviving sibling and to the disinheritance of the rest of her family. So I don't love that approach. Secondly, if at this point you've lost a half step up in basis for capital gains tax purposes, so there could be a tax issue down the road, and of course creditor exposures and loss of control, the ability to sell it, the ability to move and buy another house. I mean, there's really a lot of things going on when you throw a kid's name on the house. And again, what if she gets some kind of a financial problem? She could lose her half of the house, which is detrimental to mom. So, and all that said, you only got half protection from the nursing home. So I'm not thrilled with that result. I would suggest, and you might have said, I don't remember how long ago it was done, but she should probably set up a trust to put her half of the house in, and maybe have the sister put her half of the house back in the trust mom puts together. So now mom, basically the whole house can be protected again from the nursing home. Mom will remain in charge. Mom can still collect rent if she does rent it to her daughter. She didn't have to worry about any creditor risks. It'll be protected in 5 years from the nursing home. You get a full step up in basis when she dies for capital gains tax purposes. Folks, this is a much better way to go. So hopefully that answers the question. And again, I'm never a big fan of putting a child's name on a house while I'm living. And folks, there's other potholes that exist in the estate planning world, and that's what we have, a new guide out this month, and it is how to avoid potholes in your estate planning. And this is great for people who have already done their plan. Go look at it and see why you need to review it. There's a list of reasons. Maybe I'm older. Maybe I need to now switch to an irrevocable trust. Maybe I've moved. Maybe I lost a spouse. Maybe I've never funded my trust. Folks, people who have done their plan, there's plenty of things to learn on here. People who haven't done their estate plan, you need to read this to arm yourself so you're ready to do your estate plan correctly. There's so much information in here, and it's really appropriate for almost everyone. Call and get the guide, 866-848-5699, or go to my website, legalexchangeshow.com. You can download it there. It does take 24 hours to hit your inbox, though. Again, 866-848-5699, or go to the website, legalexchangeshow.com. Download it there.
Got another one for you, Todd. We've got Bob in Worcester on the line. Bob, what's your question for Todd Lutsky?
Hello. So my wife and I married later in life, and I owned our house. The mortgage is paid. I want it to go to my 3 kids, but I want her to be able to stay there as long as she needs to, if I pass away. So if I pass away, how do I transfer that and stipulate that she can stay there until she passes, and then it goes to my 3 kids?
So let me ask you, just confirm this. And I think you just did. You said your 3 kids. So later in life, this is a second marriage. These are not her kids, correct?
That's right.
Do they have a good relationship though with her, or not really?
Yes.
Good.
Yes.
Good. So what I would do is the plan, and this is exactly what we talk about, folks, in the guide. One of the most important reasons to do your estate plan is not always probate and taxes, right? It's the family behind the estate plan, especially with second marriages. So with second marriages, you really need to figure out how we can do exactly what Bob wants. Take care of his side of the family, but at the same time, take care of his wife without, causing his side of the family to be disinherited. Set up a trust. Now, I don't know what kind of trust you're going to need. I'll need to, when you meet with your estate planning attorney, you're going to need to learn about all the assets. How much are both of you worth combined as a married couple, and that will dictate the type of trust you do. It might be revocable. It might be one trust. It might be irrevocable if you want to protect these assets from the nursing home and for your children. And then you would probably need 2 trusts if you're worth north of $1 million here in Massachusetts anyway. So once we figure that out, then you need to put the language in the trust that's going to do what you said. So, if the house is in the trust and money, you can say, I want the property located at XYZ to be held in trust. Then you need to think about who's going to pay for all the bills, right? Well, I want it held in trust for my spouse, and she can live there her whole life, provided, however, that she pays for all the maintenance, upkeep, real estate taxes, utilities, right? I mean, there may not be money in the trust to do that. It's not asking a lot. Someone needs to maintain the property and have her do that. Now, you can also have some teeth in that language that says, in the event there's a bill outstanding for more than 90 consecutive days, well, maybe you lose your right to live there. Or, what if she's gone for more than 6 consecutive months? Again, you want her to take a vacation, that's fine. But, if you're gone for more than 6 consecutive months, the house might start falling into disrepair. Maybe you lose your right to live there. So think of the teeth that you want to put into this language, but again, giving her the right to live there. Maybe not the right to sell it. Leave that to the kids, up to you guys, in terms of how much restriction you want to put on there. And again, you might want to put language in there that says, all right, well, the money can stay in there and she can have income but not principal. Depends on what she might need, to live on. You need to look at her finances and look at her picture and see, how much you need to provide for her. And then you can say upon the death of, the spouse, equally to my kids, if that's what you want. Or you can even leave some assets equally to the kids right away. Again, be careful if you leave more than $1 million to someone other than a spouse here in Massachusetts. On the first death, you will incur an estate tax liability. Whereas if you've done your estate planning, you will always avoid estate tax planning on the first death. Again, there might be some estate tax due on the second death, but that's okay. So this is exactly the reason, folks, why you do your estate planning. This is really one of those potholes that we talk about in our guide. So we're getting close to the end of the month, folks. Learn about these potholes. Learn how to protect your assets for your family. 866-848-5699 or go to the website legalexchangeshow.com. You can download it right there.
Mr. Lutsky, thank you so much for joining us today.
Always a pleasure.
The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated. This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com.